Our daily tasks is sports performance goals, performance-related fitness, remember that, agility, balance, coordination, power, speed, and reactive abilities versus health-related fitness, strength, all categories, cardiorespiratory fitness, which is your VO2 max, and body competition. We're going to look at those. Bottom line, optimal health benefits derive from eating healthy, vigorous exercise. That's a combination of health-related and skill-related fitness. Remember that. This combination not just for sports, but for life performance as well. Remember, these two go together. And that's from vigorous exercise, but we have to build up to vigorous exercise. Physical training has to be stressful enough to cause a significant change in your physiology. That's that physiological related fitness. Essential to leading a good life. If you're strong enough and healthy enough, you can do all those things in your life that you want to do without any injury and any undue fatigue. That's what it's about. Now, let's talk about some legal considerations in Chapter 27. Why legal considerations? If you're training somebody and you're trying to help somebody, if you assist, coach, train anyone else other than yourself, that's a legal consideration because you could be held liable. If you perform your job duties at someone's home, at a company, in the outdoors, anywhere, you could be liable. There's a legal ramification there. If you use equipment of any kind when performing your duties, if you don't know how to use the equipment right or it's faulty, you could be at fault. If you give advice, assist in any form, fashion, coach, teach, etc., you can be held liable for anything that may occur on these four categories. So let's look at this. National Electronic Injury Surveillance System. Type of injury, exercise including without equipment, aerobic stretching, jogging, and running. In these years, look at the total number of injuries, and they're going up a lot with between various weightlifting equipment, exercise equipment, and all that. Total number of injuries in the table reflect estimates based on data obtained from U.S. hospital emergency rooms across the country. So you can see, depending on what the type of injury is and what type of equipment you're using, you can be held liable if it's not used correctly and you don't know how to teach it correctly. Frequent types of injuries for fitness facilities. Member malfunction. Them not re-racking the weights, dropping weights, straining muscles because they don't know how to use the things correctly, or they're just sloppy in the weight room. Premises liability. Is the premise liable for whatever happens in there? Equipment malfunction. Exercise balls that burst, cable failures, machines that are broken, they're not maintained properly, and they can cause some injuries. That's a liability as well. And it's also one of the most frequent types of injuries. Slips and falls. Treadmill malfunctions. We see a lot of that as well. Cause of injury, negligence. Negligence, which means a failure to do something that a reasonable, prudent professional would do, or do something that a reasonable, prudent professional would not have done given the same circumstances. That's negligence. If you know something's wrong but don't pay attention to it and let it happen, that's negligence. Most common injuries in fitness facilities arise from inherent risk, if you're ignoring them. Negligence and product liability. The product, the company's, whoever makes that product is liable if it fails. Law and legal systems, primary and secondary sources of law. Primary, which means statutory, which is legislative. Administration, which is executive. Case law, judiciary. And the secondary causes, sources of law, books, treatises, law review journals. You have to find out where to find that at. And help find primary sources of law or explain any area of law that could help decrease liability. Criminal law versus civil law. What's criminal law? Charges are brought about by the government when a statute is violated. Theft, unauthorized practice of medicine, etc. Uses the term guilty. If we have a medical malpractice, you could be guilty of some kind of criminal law. In a civil law, the civil disputes between individuals, businesses, and organizations. We use the term here as liable. Monetary damages are sought to compensate for the injury. So you can see the difference between criminal and civil law. Trial courts, the lowest court and first to carry out legal proceedings. So it starts at the bottom and works its way up. Appellate court, made up of a odd number of judges who review evidence of appeal. Intermediate and supreme appellate courts at the state and federal levels. So you can see how it goes up. So something might happen. It may go, somebody files a charge or something, then it goes to this court, then this court, then this court, depending on the outcome or just what it's about. Options, there's a remand, a reverse, affirm, modify decision of the lower court. So you can see it may be here, but it can be overturned by a higher court depending on what they review and what they determine. Tort and Contract Law. This is most relevant to the fitness field. What's a tort law? Conduct that amounts to a legal wrong. Causes harm on which court can impose civil liability. Remember, civil liability, there's criminal and civil law. Well, civil liability means that somebody can bring a case against you for money or damages. A contract means there's an agreement that is enforceable by a court. If you're training somebody and they sign a contract with you for this amount, you could be liable for that because they're training underneath you. If we look at tort liability, 3 levels of fault. Intentional, you intended to harm them by intent. So if you did something, you were trying to do something, if you knew something was wrong and you intended to do it, that's intentional conduct. Negligence, harm due to carelessness or neglectful conduct. And strict liability, harm due to no-fault conduct. A lot of people sign no-fault liability contracts. This, from negligence, can cause gross negligence, reckless conduct, or ordinary negligence. Now, strict liability of tort law, 2 common forms in a fitness. Talk about the product liability. There's a defect in the product you're using. And the liability is based on what is the best interest of society. So if this is determined this is a really bad product, they'll take it off the market. Or can it be fixed? Is it a good product, but maybe there was just, one time there was a flaw in the manufacturing of that. Vicarious liability, employers can be held strictly liable for harm to third parties caused by negligence of employees. So if you're an employer, you get an employee that's negligent, they could be held vicarious liability. Respondeat superior is what it's called. But you have to really watch this because the employees can be held really responsible. So if you work for somebody, you do something wrong, and it's a liability, the employers can be held responsible for it. Now, how do you prove negligence? Number 1 is duty determined by the judges. 2 is by breach of duty. 3 is causation. Was there a breach of duty? Was the cause of damage or harm? And harm and damages, harm occurred resulting in damages. Defenses against negligence, you have to carry out legal duties properly. Primary assumption of risk defense, plaintiffs are not allowed to seek damages for inherited risk. Risk must be inherent. The participation is voluntary. Participant must know, understand, appreciate inherent risk involved in that particular exercise or training. The informed consent may strengthen this defense. That's why you see people will do a health history questionnaire. They go through all this and do testing and stuff, but they also will sign an informed consent say there may be, depending on some cases and some situations, there could be a risk of injury or risk of something for doing this, this particular exercise or program. How do you have defenses against negligence? Waiver defense, you sign a waiver, defense based on a contract law. A signed waiver indicates that an individual gives up any civil right to recover damages for ordinary negligence. So you can see the tier system here, how things are associated with different types of negligence. Some waivers are not enforceable in certain states. Just because you sign a waiver doesn't mean if the person harms you, a certain type of neglect, doesn't mean that it is enforceable in all states. So some you can't modify or alter. So it just depends on the state, you know, how seriously they take this. Contract law. Let's give some examples in the realm of fitness. For waivers, informed consents, employment contracts, independent contractors, membership contract purchase, and lease agreements. To be legally valid, the contracts must meet the following: agreement, offer, and acceptance; consideration, money paid for services rendered; contractual capacity, both parties must have the capacity; and legality, contract's purpose must be legally binding. 3 laws applicable for the fitness: Americans with Disabilities Act, and Occupational Standards, Health Administration, bloodborne pathogens. This is administrative law. It's reduce or eliminate exposure to pathogens via the blood. That's why they're very careful about gloves, you know, any kind of exposure to, if you cut your finger, somebody's exposed to somebody's blood, that's the administrative law has, there's protection. Requires written exposure control plan. Health Insurance Portability and Accountability Act, the HIPAA. Mandates protection of private health information. You can't give away somebody's information. Questionable whether or not health and fitness facilities are mandated to comply, but it's probably wise to do so. Don't give away somebody's information. And then releases are required for fitness professionals to obtain medical information regarding a participant. This is going back in for liability purposes and signed consents and all that. So you have to sign releases, but you want to collect as much data on that person involved to see who is at risk, both you and your client. Now, considerations determining duty. Is there an inherent relationship between plaintiff and defendant? Is there a professional standard of care? Is there a special relationship between a person on the property and a landowner or occupier? Trespasser, licensee, invitee. Invitee is owed the highest level of duty. So you got to look at that. For example, because a fitness professional has special skills, there are exceptions associated with the use of those skills, professional standard of care. Now, this is why there's so many certifications out there and stuff too, because certain companies require certifications to say you are minimally qualified to perform this particular type of skill or activity or be able to teach that. So that's a huge liability factor. Public standards of practice. Standard minimum requirements that a fitness facility must meet. So that's the fitness facility. Guidelines and recommendations to improve quality of service provided. In other words, you have to, everybody in the club does, or the company, and all the employees must meet a certain standard to be able to give these services. Standard guidelines, position papers reflect benchmark behaviors. This is from most of the major organizations: ASCM, ACSM, NSCA, AMA, MFA, AFA, and the YMCA. Most of us have heard of these particular organizations. They've been around a long time, so they know they have to have a certain quality of person working for them, and they have to be certified. The American Society for Testing and Materials, and the Consumer Product Safety Commission. What's risk management? Reduction of accidental losses to prevent slowing in growth, reduce profits, interruptions in operations. 4 steps. Assess the liability exposure. What kind of liability are you being exposed to by a number of different things, from people that aren't well informed, equipment, members, could be a lot of different things. Develop risk management strategies. How do you decrease the risk? You know, what kind of strategy? Once again, you make a training plan, now you have to make a risk management strategic plan to prevent any kind of risk. Implement a risk management plan. Once again, it's like a business plan. You have to implement it, then you have to go along the guidelines and evaluate that management plan. Once again, it's just like a training plan. You put it into plan to see if it's working, then you have to evaluate to see, is what you've put down really keeping you safe? Minimizing legal liability from your personnel. They've got to be qualified. Pre-activity screening, fitness testing and prescription, instruction and supervision, equipment and facility, emergency action plans. But let's take a good look at this. So if you want to minimize legal liability, your personnel has to be educated. They have to be properly trained. They have to have some kind of experience to be able to do the screening to see what level their client is at, if there's any risk involved from a legal point of view or a health risk point of view. And you have to be able to initiate or implement fitness testing, and not prescription, it's a suggestion about, we think you should do this about that. Because if you don't know how to perform the test well to collect the data, your client could be at risk and the club could be at risk. Instruction and supervision. Don't try to implement some kind of movement pattern or instruct an exercise if you don't know how to do it and you don't know how to supervise properly. Can you describe it? Can you observe it correctly? Can you evaluate it properly? And then can you instruct properly? All the equipment and facilities must be minimum standard for care of the client. Is equipment working? Facility clean? Bloodborne pathogens? Can you decrease that risk and all that? And do you have any kind of emergency action plans if something goes wrong? Record keeping. Once again, we talked about this the last slide, your staff credentials. What are their credentials? Education, certification, experience. You need to run a criminal background to make sure that they don't have a past background that could impede or harm the clients or the reputation of the club. Staff trainings. You should have ongoing education for all these people to make sure they're doing things properly and they decrease the risk of injury for any client. Pre-activity screening forms, we've talked about that. Waivers and consent forms. Medical releases. Written guidelines for on scope of practice within the club and within the training guidelines. Participant facilities orientation. How does the facility operate, and how is you as a participant, how do you follow within those guidelines? How does it work? Job performance appraisals of staff members. Are they doing their job accordingly? Are they meeting the minimum standards? Are they helping improve people? Are they keeping people safe? Facilities and equipment inspections. Make sure nothing's broken. You got to go through the club and make sure that it's safe for that person to use this equipment or use the club or use some part of the club. Facilities and equipment maintenance, that's a given. Fix it. If it's broken, fix it. If it's broken, put a sign up that says don't use this, because if you use it, you could get hurt. And it also helps you with your own liability against some kind of suit. Written emergency action plans. Completed incident report forms and related evidence. So if something happens, write everything down. It's like law enforcement officers will have to do an investigation. If they have an incident, they have to write everything down to make sure everything's in order, so they have the evidence in case somebody comes against you and says that didn't happen. Yes, you have the evidence. And written exposure control plan. All right. So for that's the end of Learning Module 1. We have some questions we'd like you to answer, all that and everything too, so let's go from there.